All rise. The Circuit Court of the State of Oregon for Lane County is now in session. The Honorable Gregory Foote presiding. Be seated.
Good morning. This is a matter of Clark and Clark here on the motion for authorizing sale of residential property. I'll hear first for the respondent.
Your Honor, we referred to Mrs. Clark as the petitioner. It's a consolidated case.
Oh, I see. Okay.
And basically, there are three outstanding judgments. One for spousal security, principal amount $66,000. Another principal amount for costs and fees of $5,360, and a third one for $1,907. So what we've done is we have a number of exhibits that Ms. Clark can identify with regard to the title report indicating the judgments, the calculation of interest, and a per diem, which is required by statute for the sheriff, and the Lane County property tax statement indicating the assessed value of the real property is $323,000, which is important in the sense that one of the prerequisites there is to make sure that after the homestead exemption that there is money available for the judgment creditor. And finally, we also the total amount that we're collecting on here has been reduced by $1,451.65, which was the result of a garnishment of an IRA account. So I just want to put that on the record, and we will be filing a satisfaction with regard to that amount.
Very well. May I call your first witness?
Amy Clark.
Come forward, please, and raise your right hand. Under penalty of perjury, to swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Take the stand, please.
Ms. Clark, state your full name and spelling, please.
Amy Marie Clark, C-L-A-R-K.
And Ms. Clark, do you have some outstanding judgments against Amy Clark?
Yes.
May I approach the...
Yes.
I've provided Mr. Clark with copies of these exhibits. Quickly identify them. What's marked as petitioner is exhibit number 1, and it's that certified company guarantee exhibits 1 and 2.
Yes.
What's marked as petitioner's exhibit number 2 is a calculation of spousal support owing and the copy of the document judgment.
Yes.
What's marked as petitioner's exhibit number 3 is the same material in regards to the second judgment.
Yes.
This one is exhibit 4. $1,007.
Yes.
Finally, petitioner's exhibit 5 is that shows Lane County property tax statement showing the real market value of $323,000. Is that correct?
Yes.
I'd offer exhibits 1 through 5.
Any objections, sir?
To that, should I ask questions?
No, I'm just asking if you have any objections to his offer of the exhibits.
Not at this point. I'm trying to, no.
They'll be received?
And Ms. Clark, the total amount of these judgment it's 73,000 and so many dollars. Are you asking the court today to authorize the sheriff to sell real property?
Yes.
And does he own property at 3270 Stone Ridge Road, Eugene, Oregon?
Yes.
That's all I have.
Do you have any questions you want to ask?
Of the witness?
Yes.
Yes, Your Honor.
Go ahead. You can stay seated.
Yes, thank you, Your Honor. In your affidavit that was used as the basis of the motion, you claimed an urgent need for this money. Is that correct?
You're going to object in this because that's not what the motion said.
Again,
Which affidavit is this, sir?
it's her affidavit where she,
Which affidavit?
if I don't have them with me, I didn't
Well, if
bring
you're
it.
talking about the motion, the affidavit for expedited hearing,
Right, it's where she notes that there's an urgency.
okay, if you're talking about the affidavit in support of the motion for expedited hearing, that would be irrelevant, because we are here and we're having a hearing, so the only issue is that it's set forth in the motion for order authorizing a sheriff's sale.
Right. Let me ask some more questions. Did you on February 28th have $80,000 in a bank account?
That's sustained?
Did you on February 28th induce your attorney to input financial records of my parents without their permission, which they've since sent an affidavit where they don't want that information in the court, where they say it is not a source of income
Sir,
for me?
this is not before the court today. Okay, the only issue before the court is whether these judgments are valid and whether the property should be sold.
Again, Your Honor, I don't believe they're valid judgments because on the exclusionary rule, Fourth Amendment exclusionary rule,
The court cannot go behind the judgment at this point.
the court needs to deny them their judgment or their ability to sell the house because it's predicated upon bad data. It's the fruit of the poisonous tree.
Well, that's a criminal concept, counsel. This is not a criminal case. We're here simply to determine whether these judgments exist and whether or not the property should be sold.
The property shouldn't be sold. It's my home, and the judgments, again, are based
All right,
upon...
well, I sustain the objection. Okay, so let's move on. Any further questions?
How many homes do you own already? Two that I'm aware of. You own one in Fox Hollow, one on Friendly Street.
Objection.
Why do you own my house?
That's sustained.
Pardon me?
What she owns is not relevant. Okay? The only issue is are these judgments valid and is the house, is its property subject to sale. What she has or...
It's not a legal sale under the law. They can't do it for spousal support. It's not, it's the whole basis of taking a man's home and selling
Okay,
it.
sir. We have a witness on the stand. Do you have any further relevant questions?
I don't know what a relevant question would be. I'm telling you. The whole thing...
Ask the question, and if counsel wishes to object, he will object, and I'll rule on it.
Are you willing to accept any other way to get the money so that you're not throwing me out of my house?
I object, Your Honor.
That's sustained.
Okay then, I see where this is going. I don't know what else to say. I just don't feel it's a right thing to do.
Well, she's just testified, counsel. You can...
I'm not a counsel. I don't know.
Sir,
I can't.
I'm sorry. She's just testified. You can ask her questions about what she's testified to. Those are the issues that are relevant to the court.
But the court has to exist.
The court does not have to do anything that's not required by law. This is a limited proceeding. The only issue for the court is, are these judgments in existence? And is the house, the residence subject to sale to satisfy?
They're under appeal. They've been moved motion for
Then
sunset.
another court will take those matters up. I cannot do
And the house
that.
is sold already.
All right, listen, I'm not going to argue with you, sir.
Yeah.
Do you have any further questions?
No, I don't.
All right, you may step down. Sorry, do you have anything? All right, step down, please.
Okay,
Do you wish to present any evidence?
I don't know what evidence has relevance here, Your Honor. I'm finding the
I've told you what the two issues are.
It's whether they're valid judgments, and I say they're not, but you say they are. And whether it should be sold, and I'm saying it's my only house, and I only have a place to live, and I'll be on Little Street. And no one seems to care about that greater social need of somebody being on the street, well, there's a wealthy person taking the money. It's just wrong. And by breaking it into these little pieces, it's very difficult to fight it. It's hard.
Well,
It's not a legal process where they can wait 6 months to hear it. I don't have a job. The whole thing is predicated on $5,500 because I don't have a job. And they never would hear it. Don't you think the wrongness of it, Your Honor? When something's this wrong, it has to just be said, wait, just put this on hold.
I'm asking if you have any evidence to present.
Evidence of what? The fact that she has the money, she testified to it, but it doesn't matter. The fact that she has houses,
Sir,
it doesn't matter.
Sir, look, this is not the time for argument. This is just the time for you to present any evidence on the issues before the court today.
Well, I feel
I know what you feel, sir, but that's not before the court.
That's the way it is then.
Well, all right.
I don't have anything else. I'm trying to give you my soul, like, what I know is right, where there's someone who's got a lot of money and they've used a lawyer to court incorrectly to get us here today.
Well,
And that's a problem. It's a big problem for the system. And I'm trying to do things around it. I put it in the federal court for injunction. I'll have to talk to that judge again today. And see, I'm doing the things I can. I'm not going anywhere. I'm not hiding the asset.
I'm fine, sir. I've indicated what I believe the issues are. You've indicated you don't wish to present any evidence on that. Is there any further evidence for your claim?
No.
Well, it appears to the court that there are valid judgments. I didn't get the actual exact total. Did you total those up?
It goes up by the minute. Every minute we sit here, it goes up more and more and more. He gave us $10,000 bill for a hearing in February. $10,000, remember? Don't you as a human being have any conception of what $10,000 is?
I do, sir, and I'm explain to you what the.
I guess I have to just do the appeals, do whatever it is. I don't know what to do anymore. They're displacing me.
I'm going to grant the motion for an order authorizing the sheriff's sale. We need an amount, and I make the finding that the value of the house exceeds the value of the judgment, exceeds the amount of $3,000, which is I think the limit that's listed in statute. It also exceeds the amount of the homestead exemption, which will apply. Well, can that simply be presented in the order, counsel? It's 73,000 plus, right?
That's correct.
Yeah, maybe dismissed, John. I see where this is going, and I've got to get on with it now.
Well, all right. Well, I'm going to ask Mr. Newton to present the order to the court. I will note that I'm only here today.
I'll bring it.
All right.
How fast do I have to get out of my house?
As long as, well, we're still on the record, I would tell you something. The amount, total amount due, including whatever we've incurred prior to the sale, of course, we could avoid the sale.
Maybe we'll do that while I'm busy suing a few people. Okay, I'm going to go. I'm not feeling very well.
Very well.
What's happening? Thank you.
We're in recess.